Good evening, everybody. My name is Abhishek Dagur. I am a part of Royal Defence Academy family. We are continuing with this YouTube series lectures of the topic Constitution and largely Indian polity. In the last two videos, I have tried to cover some parts of our Constitution. In the last video, I discussed about some fundamental rights. Broadly, the right to equality and right to freedom. You must have seen that these rights are very much important. The right to equality is important to create a just society in India. There are various sections of Indian society that have been discriminated against in the past. There are various historical injustices that has been done to them. In order to remove these injustices and uplift these societies, these segments of society, for example, the scheduled caste, scheduled tribe and other weaker sections, the constitutional framers have ensured that there is an article called right to equality. Group of article. These group of article are from article 14 to 18. Right to equality implies that everybody in India has equal rights and they are treated similarly in the eyes of the law. But we have also discussed about the equal protection of law concept. It means the state can give special preferences with regards to employment and educational qualification, etc. for certain weaker sections of the society. This is not a measure of discrimination against the general classes or the uplifted classes, but in fact this is a means to uplift the already weaker sections which are still there in our society. This concept, equal protection of law, is also found in the Constitution of United States of America. There are also certain positive rights which are given to the blacks in USA. After that, we also discussed about the right to freedom. Right to freedom, as we all know, is very much important for a democratic polity. In democracy, every citizen of the country has a right to express his opinion, has a right to protest peacefully, has a right to show discontent against the state or the government. So, in this way, our democracy gets strengthened from Article 19 to 22. After that, we are continuing and we will be finishing the rest of the fundamental rights in today's topic itself. The next fundamental right which we are going to discuss are right against exploitation, which are mentioned under Article 23 and 24. As the word implies, these rights are given to protect certain people, certain segments of the society against exploitation, from exploitation. Article 23 talks about the prohibition of human trafficking and forced labor. Slavery, as we all know, in the last 3 centuries, the slavery has been a dominant form of practice which was continued in various European as well as African as well as North American countries and also in India. Those sections of society which were vulnerable, that were poor, that were discriminated against, that were weaker, were also made to indulge in the slavery processes. They were not paid anything by their employer and they were forced to work in a meager wages or no wages at all for longer period of time. This practice was continuing in India also, though the British Empire had banned slavery in 1850s and 60s, but there were various other forms in which slavery was being practiced in the British Empire. It had been practiced continuously till our independence. When we got our independence, when the Constitution was drafted, Article 23 of the Constitution ensured that the forced labor is prohibited by the law. In India right now, if a person has employed any other person, he has to give certain amount of money. That employer cannot forcefully employ a particular person. Minimum wages have to be paid. This is said by Article 23 of the Constitution. Prohibition of human trafficking. Human trafficking implies that human trafficking generally means the purchase and selling of human beings. As a human being human beings do not have any value. Their value is infinite, so they cannot be purchased or sold in any market, etc. This practice is illegal. We know that especially women and children are vulnerable to this practice of human trafficking. They are a vulnerable section in our society, so special constitutional protections were required to be given to them. That is why Article 23 ensures that there is no human trafficking that can be practiced in our country. This is also a measure to create a just society in India. The Article 24 talks about the prohibition of child labor. Any child below the age of 14 cannot be employed for an economic activity. You must have seen various children, some children being employed as chai ka thela and all these local shops, etc. But this is an illegal activity. They cannot be employed. But those children, either they are orphan, etc., or they have some condition. But it is the failure of the state because of which these conditions are not able to be educated and hence utilize their full potential. Utilize their potential, and they are being employed in the practice of child labor. But this is illegal according to the law. Article 24 talks about it. Article 23 and 24, as I have discussed, both protect the vulnerable groups, vulnerable sections of Indian society, especially women and children. The next group of article which we are going to discuss is the right to freedom of religion, Article 25 to 28. We all know that India is a secular country, apart from being a democratic country. In a democracy, citizens have certain rights. And also in a secular country, all the religions, all the people who practice different religions have their own rights. In India, anybody can practice its own religion. There is a freedom of conscience, freedom to practice, freedom to propagate, freedom to manage religious institutions and affairs. We are going to discuss about this article in detail right now. Article 25 basically gives the right to freedom of religion. It mentions right to conscience, the freedom of conscience. The word conscience here implies that a person has a full right to believe in a particular religious ideology, whatever it is. It can be Hinduism, it can be Christianity, it can be Islam, it can be Sikhism, it can be Zoroastrianism, etc. A person is free to follow any religious ideology. The state cannot bound any person to follow a certain religious ideology, or any private person also cannot force an individual to follow certain ideology. This is the meaning of freedom of conscience. After that, Article 25 also talks about freedom of right to practice. This means that whatever conscience a person is following, whatever religious ideology a person is following, that particular individual also has full right to practice its ideology. The meaning of practice is that there are certain procedures, rituals that are mentioned in religion. These rituals are to be followed if a person has to follow certain religious ideology. For example, there are certain festivals that are celebrated according to different religions. So, celebrating a festival is a part of practicing that particular religion. So, in India, every individual also has a right to practice certain religion. After that, we also have a right to propagate the religion. all of you, any individual has a right to spread his religion, not forcefully but peacefully. A person cannot forcefully convert other person to his religion, but a person can spread its religion's own ideas, and after that, if other person is getting inspired from these ideas, then if that person is able to convert, is being getting converted, then it is allowed. Forceful conversions are not allowed according to the law in India. This is the meaning of right to propagation of religion. Article 26 talks about right to manage religious affairs. Article 26 guarantees the right of religious denomination and for the spread of a religion, as you have already seen, or for practicing a religion, there are various religious institutions that are established in different parts of our country. For example, madrasas are established. For example, temples are established. For example, mosques are established, churches. Article 26 gives you the right to establish these institutions, to spread your religion or to practice your religion. These religious institutions helps a person in practicing or spreading its own religion. So they are very much important. This is also a basic feature of secularism in India. I have already discussed there is a freedom to manage religious affairs, but this article is also subjected to public order, morality and health. Let me give you an example. Article 25 and 26 both are subjected to public order, morality and health. What is the meaning of it? You must have already seen that in Maharashtra, a huge procession takes place on roads during the occasion of Ganesh Chaturthi. This is primarily the example of secularism or the right to freedom given by Article 25. You can practice a peaceful procession of Ganesh Chaturthi on roads. But during the time of pandemic, Corona pandemic, the district collector of that area has the power to stop that religious procession because it was not in the interest of health of larger section of the society. If more than 5 people gathered at that place, then the Corona pandemic would have made the serious condition worse in that particular state. So the government also has the right to curtail your right to freedom subject to public order, morality and health. If there is a law and order problem in any area, the district collector can impose section 144 and of CRPC, and hence your right to freedom of religion can be curtailed. Article 27 talks about freedom from paying taxes for the promotion of any particular religion. This is basically the right to equality with regards to religion. The state cannot impose certain taxes for the propagation or promotion of any religion. For example, the temples in India are tax-free. They do not pay any taxes. Mosques do not pay any taxes, and all these religious institutions do not pay any taxes because for the promotion of religion, Article 27 prohibits the payment of tax. However, certain fees etc. can be applied to that particular religious institution, but that fee must also be used for the maintenance of that particular religious institution. Okay. Article 28 talks about freedom from attending religious instruction or worship in certain educational institutions. For example, in government educational institution, in government schools etc., the religious instructions cannot be taught. You must know this fact. If a religious instructions are being taught at that place, it is then the violation of Article 28 of the Constitution. This is the meaning of freedom from attending religious instructions. Now coming to Article 29 and 30, there are certain cultural and educational rights. Article 29 safeguards the right of minorities to preserve their culture, language and script. As we all know, there are various types of minorities in India. We have various tribal minorities, religious minorities, etc. These minorities are very vulnerable with regards to current situation in India. A special effort is required for these minorities to preserve their culture, preserve their language and script. We all know that more than 1000 languages and script are vulnerable and are on the verge of extinction in India. A special effort is required. The Constitution also mandates under Article 29 to preserve these scripts. So Article 29 safeguards the right of minorities. Minorities can take special action to preserve their culture, language and script. This is the meaning of Article 29. Article 30 talks about right to administer the educational institution. Basically, this is the right of minority to establish educational institution. You must have heard about the word Jamia Millia Islamia, or in short JMI. This is a minority educational institution. This institution has been set up to preserve the culture of Islam. Aligarh Muslim University has also been set up, and there are various other institutions that are being set up. By what article they are set up? They are set up under Article 30 of the Constitution. The minorities are given certain rights to establish these educational institutions. The cultural and educational rights are important to maintain the cultural diversity, protect the religious and ethnic and other types of minorities, preserving their script, preserving their language, preserving their culture, etc. Now there was also an article 31 in Constitution when the Constitution was drafted in 1950. Article 31 talked about right to property. It is a feature of classical economics, or basically capitalism. Right to property implies that whatever property you have owned from your hard work, you cannot be forced to sell that particular property by the state. Your property rights are safeguarded by the state. They cannot be violated. This is the meaning of Article 31, right to property. But this article has been removed from the Constitution. Article 31A, right to property, is no longer a fundamental right. It is just a constitutional right. We will be discussing in later classes what is the difference between constitutional and fundamental right with regards to right to property specifically, when we will be discussing Article 300. After the Article 31, another fundamental right which is called as the heart and soul of Constitution by Baba Saheb Ambedkar. As you can see, the heart and soul of Constitution, it means that this article is the most important article in our Constitution, or largely the fundamental rights. Article 32 basically means the right to go to court. In case your fundamental rights are violated, if you feel that state or any private citizen has violated your fundamental right, then you have the right to go to court, especially the Supreme Court, directly, and you can plead to the Supreme Court that, sir, my fundamental right has been violated, please give me remedy. The Supreme Court is bound by the Constitution. Supreme Court has to give you the remedy. Supreme Court has to protect your fundamental rights. By the way, this is one of the reasons there is a large judicial pendency of cases in Supreme Court. So you have the right to constitutional remedy. You can seek remedy of fundamental rights given in the Constitution through the Supreme Court or High Courts in India. Largely the Supreme Court, basically. There are various writs mentioned in Article 32 of the Constitution that are habeas corpus, mandamus, prohibition, certiorari and quo warranto. The most important among it is habeas corpus. Habeas corpus writ is the guarantor of individual liberty of a person. The state, suppose if a state has forcefully detained or arrested a person, then his family or any other relative of the person can go to court and can demand the court to issue the writ of habeas corpus. It means that bring the body of the person who has been arrested has to be produced before the magistrate, the judicial magistrate. This is the meaning of habeas corpus. He cannot be detained illegally. So we have already discussed right to move to Supreme Court under Article 32. Article 32 also mentions about the enforcement of fundamental rights. Article 32 also talks about writs. Writs are the mechanism used by judiciary, higher judiciary, to protect the fundamental rights of the individual citizens, and it is a remedy. Baba Sahib Ambedkar has already said that this is the most important article and it is the heart and soul of our Constitution. After that, there is an important article that is left, Article 359. Though it is not a part of fundamental rights, but it is associated with fundamental right. Article 350 to 360. In our Constitution, talks about certain types of emergencies. Article 352 talks about the national emergency. Article 356 talks about governor's rule in the state, and Article 360 talks about financial emergency. In these types of emergencies, the central government occupies unlimited power with regard to the state government or the individual citizen. If an emergency is imposed under Article 352, that is the national emergency, the central government has the power to suspend your fundamental rights. Your right to equality, your right to freedom, your right to go to courts, etc. can be violated if Article 352 has been applied in any part of the territory of India. This is the meaning of suspension of fundamental right. This measure is given in Article 359 of the Constitution. It has been mentioned. But various Supreme Court judgments have stated that Article 20 and Article 21 these rights cannot be violated by the state even if an emergency has been imposed in any part of the country. These rights are supreme. For example, Article 21 gives you the right to live, right to life and individual personal liberty. The state cannot kill you without any cause, arbitrarily.